Welcome to episode number 228 of AAA Weekly Knowledge Series. Today we are discussing about National Tribunals Commission. So why we are discussing about it is because this has got direct relationship with Insolvency and Bankruptcy Code, because see, NCLT and NCLAT capacity is a big issue in the complete implementation of the IBC. We also would like to understand, because if there is a delay in adding more members to NCLT or NCLAT, there are some reasons. We normally feel that the government is inactive, but it is actually not. The government is acting, but it is only because of the decision of Honorable Supreme Court in December 2025, when the central government was directed to set up a commission. So that's what the central government is doing now. I believe till the time this would be done, the recruitments may have been kept pending. So let us discuss what the Tribunals Reforms Bill 2026 is. Now this bill was presented before Lok Sabha and it was passed by Lok Sabha on 10th August 2026, and it was also passed by Rajya Sabha on 11th August 26. It will also get President accent by the time we publish this video, but the one and only one objective of this particular bill is one, to repeal the Tribunals Reform Act 2021, which Supreme Court was criticizing, and also to set up and establish National Tribunals Commission. We can say NTC, or we can say the commission in our rest of the conversation. So this will be a freshly created architecture whose centerpiece is the establishment of NTC, National Tribunal Commission, and it would be a permanent expert body which will be headquartered in New Delhi, basically to conduct this National Tribunal Commission will conduct the recruitment, selections, review their performances. Their performances will also be reviewed. So all the tribunal members, judicial or technical, their performance will be monitored annually, and a report would be submitted to central government. And also it will be seen, their complaints also would be seen, it will be overseen by this commission. They would be maintaining a national tribunals data grid, and there are 16 tribunal which has been notified through this act, which will come directly under National Tribunal Commission. Although NCLT presently is not included in the list of 16, but NCLAT is included. But I understand there is a section 18 subsection 2 of the Tribunals Reforms Bill, which gives powers to the commission to notify, because the NCLT was originally formed in the Companies Act. So maybe the Companies Amendment Bill, which is also pending before Parliament, maybe some kind of tweaking is required in that bill. So therefore, this NCLT is for the time being kept pending. It will be notified once it is kind of Companies Act tweaking is also done. It will take maybe some time. Now, this basically the Supreme Court judgment which came, that was in the case of Madras Bar Association versus Union of India. This was the judgment dated 19th November 2025. The court in fact held three legal issues which in fact was framed in this case. One was, could the Tribunals Reform Act 2021 fix a 50-year minimum age, a 4-year term and a 2-name per vacancy rule? This was the first legal issue. The Supreme Court held that no, these were the same provisions the court had earlier struck down in Madras Bar Association 4, because see, there has been various petitions known as Madras Bar Association 1, 2, 3, 4, 5. So in MBA means Madras Bar Association 4 and also 5, this was struck down by Supreme Court. The Parliament has simply reenacted them, and the same sections like Section 3, Subsection 1, Subsection 7, Section 5 and 7 of the 2021 Act, that was in fact struck down for violating separation of powers, judicial independence and Article 14 of the Constitution. So therefore, reenacting the same act is something which is not right. It was held as not correct. Second question was, can Parliament reenact a provision the court has already invalidated? The Supreme Court said no, the Parliament may pass a fresh law only if it cures the defect the court identified. Repeating the struck down text in a new statute is an impermissible override of judicial review. This is what the Justice Vinod Chandran said, old wine in a new bottle is not permitted. Issue 3 was what happens next. So then the Supreme Court said that the Union must establish an independent National Tribunals Commission within 4 months. This is a constitutional obligation, not a choice. Until then, sitting members are protected. So therefore, 2026 bill was to the compliance of that Supreme Court order in the case of Madras Bar Association. No, this bill actually matters a lot. Why it matters a lot? Because the NCL 80, DRT, DR80, wherever CIRP and personal grantor matter are heard and are adjudicated, they are inside this new National Tribunal Commission. So therefore, it is relevant to all insolvency professionals and anyone who actually is practicing insolvency or DRT SARFAESI law. So we primarily as AAA, we are practitioners of SARFAESI law as well as insolvency law. So therefore, this becomes relevant to us so that we understand the constitution of our benches, and if it is pending, then we should know where it is pending and when it is likely to have the required capacity. So let us understand what prompted this enactment. So in fact, I have already touched, like there were originally this Finance Act 1917, Finance Act 2017 and the rationalization. See, the central government began rationalizing the tribunal system in 2015. In fact, Income Tax Appellate Tribunal in India was the first tribunal. So the Finance Act 2017 merged or abolished several tribunals and empowered the government to frame rules for appointments, tenure, qualification of chairperson and members. So these 2017 rules framed thereunder were struck down in Roser Matthew versus South India Bank Limited case by Honorable Supreme Court for defects in selection mechanism, lack of judicial dominance in search cum selection committees and tenure framework. So this was the first trigger. The second trigger happens in the Madras Bar Association line of cases, because as I said, Madras Bar Association, in fact, this began with the 2010 case where Union of India versus R. Gandhi, and then Madras Bar Association 3, Madras Bar Association 4, 3 happened in 2015, 4 happened in 2021, and 5 is in 2022. And now the latest judgment in the case of Madras Bar Association. In fact, basically the Supreme Court is consistently laying down the tribunals discharging judicial function must enjoy safeguards of independence comparable to courts. Judicial dominance in selection, secure 5-year tenure, no arbitrary minimum age bar, single name recommendation, and freedom from executive control over service conditions, the government being the largest litigant before most tribunals. So the last one, I'm not sure how it will get actually resolved, but there are many other issues which are actually getting resolved. Then of course the government came out with the Tribunal Reforms, Rationalization and Conditions of Service Ordinance 2021, which was in fact promulgated in April 21, and finally it was replaced by Tribunals Reforms Act 2021, and it was reenacting the same provisions like 50 years minimum entry age, 4 years term, and at least two names would be recommended before the panel, and so this was the Madras Bar Association, and then finally this bill came. So now when we understand this bill, so basically there are definitions, and what we need to understand is that this National Tribunal Commission is actually being established now. It will be established with 4 members. So it will have a headquarters in New Delhi. It comprises of 4 members. 1 chairman, which will be a former Supreme Court judge or Chief Justice of a High Court. So therefore, the age and the tenure of these members of NTC is kept as 5 years or till the time they achieve an age of 70. 2 judicial members, they should be former Chief Justices or judges of High Courts, and 2 technical members. The technical members should be, again, the technical members as we have seen in NCLT and NCLT and NCL80, like the persons of ability, integrity, standing with at least 25 years special knowledge and experience in public administration, finance, law, accountancy, banking, management or technology. So the four will be members including one chairman. That is what is the constitution of NTC, National Tribunal Commission. Now they have actually been given powers as per this bill. They would be conducting selection of vacancies of chairpersons and members of scheduled tribunals. I will actually come to the scheduled tribunals. So first of all, I think that's important that I should come what all tribunals are covered in this bill. So I would actually start with the CSTAT. The first tribunal which is listed in the schedule is CSTAT. CSTAT is a tribunal for custom matters. Then appellate tribunal under SAFEMA, and that also covers the PMLA. So that is the appellate authority under PMLA as well. Then Central Administrative Tribunal and State Administrative Tribunals, like that is Administrative Tribunals Act 1985 regarding the service matters. Then Railway Claim Tribunal. Then Securities Appellate Tribunal, that is under the SEBI Act. Then Debt Recovery Tribunal under the Recovery of Debt and Insolvency and the Bankruptcy Act, RDB Act. Then Debt Recovery Appellate Tribunal. Then this is TDSAT. TDSAT is for all telecom disputes. Then Appellate Authority for Electricity under Electricity Act. Then Armed Force Tribunal, and then National Green Tribunal, that is for environment. And then National Company Law Appellate Tribunal, NCL 80. And then National Consumer Dispute Redressal Commission, basically NCDRC, National Consumer Dispute Redressal Commission, an industrial tribunal constituted by Central Government Industrial Relation Code, and income tax appellate tribunals. Everything actually has now come under this National Tribunal Commission. Now we have already seen like what would be the constitution of this NTC, and also their appointment. One, that their appointment will be for 5 years or till the time they achieve the age of 70. Whichever is earlier, that is what is their duration of appointment of members, including chairman of NTC. Now, we shouldn't discuss about the salaries and all that, but then the question is the resignation and removal of chairperson and members, that is also provided in this. Vacancies, etc. Because if there is any vacancy, still the decisions can be taken. If there are not 4 members, there are 3 members, the decisions can be taken. Over and above, there will be a secretariat of the commission, and there will be a central government will also appoint an officer of secretary to the government of India rank as secretary of the commission. So anyone who actually would be of the rank of secretary to the government of India will also act as the secretary of this commission. So this particular secretary will head the secretariat and exercise the prescribed administrative and financial powers, subject to the general and oversight. That of course, chairman will have the general oversight, how the meetings will be conducted. In fact, the meetings are also governed by the regulations. Now, the question is that this commission will also make regulations. The regulations regarding what would be the process of recruitment, then examining, interview. So there will be regulations which will be made by this commission, and there will be rules which will be made by the ministry, because this has been made by the Ministry of Law and Justice. So the Ministry of Law and Justice will also make rules to handle various issues or to provide complete process. So that also will be provided. So the entire expenditure will be met by the government. It will be audited. It will be under CAG. All this is okay, but then there will be one annual report would be furnished. The secretariat, the secretary to the government of India, who actually would be heading the secretariat of NTC, that would actually prepare an annual report of the commission's activities, which will actually forwarded to the commission, to the central government, and also before each house of parliament. So this is also one important part. Now the other is the setting up of search cum selection committees. So how the search would be done, that also would be provided in the regulations. The selection process, how the committees will be constituted, that is what is defined here. For selecting a tribunal chairman, the committees actually should constitute chairman of the commission with one technical member, with a retired High Court Chief Justice nominated by commission's chairperson. One High Court Chief Justice also retired. And then the Government of India Secretary nominated by the central government, that is the Chief Secretary of or it can be a Chief Secretary of the state. 2 empaneled experts. So a committee would have 1 chairperson, 1 technical member, 1 retired person, 1 secretary, and 2 the empaneled expert who assessed the candidates, and a secretary of the commission as the non-voting member secretary. The secretary will coordinate. Secretary will be part of the search cum selection committee, but the secretary will not have a voting. He will not have the voting, but in case, let us understand, chairman, 1 member, 1 High Court Justice, 1 Secretary to Government of India, 2 experts, and then 1 secretary. 7-member committee, 6 would be voting, 1 secretary would not be voting. So they would be selecting any tribunal chairman. So they would be selecting any tribunal chairman, and similarly for other members also the search cum selection committees would be made, but almost on the similar method. So we have seen search cum selection committees, but one thing is very important: the search and selection committee can only make recommendations to government. The commission, this commission does not have any power to directly recruit. It actually will send the recommendations to the administration ministry. Because see, any ministry which is administrating the tribunal will have the final say, and then only the central government will say yes to a particular recruitment. The tribunal cannot exercise any direct power, as well as the central government cannot exercise any direct power of recruitment. So this one is very important. But now what has happened is, there are 16 tribunals which are covered by this bill. Now all the existing enactments, regulations, rules regarding qualifications, selection process, appointments, salaries, resignation, removal and service conditions of the tribunal chairpersons and members, presidents, that actually is presently all getting overridden. All will be getting overridden, and fresh rules will be made and fresh regulations will be made by the National Tribunal Commission. So the government will make rules, whereas the regulations will be made by the commission. See, this section 14 actually of this bill is very important, which says that the appointments are made by central government, but only on recommendations of search cum selection committee under section 13. The government cannot appoint someone the committee has not recommended. Subsection 3 says, for a chairperson's post, the search cum selection committee itself decides whether to fill it by selection process. Selection process means advertisement and application, and there may be some criteria, and how that criteria is being fulfilled by even approaching candidate. And then it actually would be a separate process, will be considered as a search process. So there may be some senior positions where some senior persons would be required, and the commission may think that people will not apply. Anyone who is the most eligible will not apply, so they'll have to search. So that process, whether it will be based on a selection process, which means advertisement, etc., or search process, that will be decided by the search cum selection committee. Then the search cum selection committee must follow a prescribed comprehensive assessment procedure. The finer mechanics, scrutiny of applications, and the weightage given to assessment criteria, that actually will be the power of the NTC to make regulations, and not the government. Government will make only the rules wherever it is required, but this procedure, that actually will be made by NTC. A sitting or a former chairperson member applying for reappointment is assessed on previous work performance in the tribunal. For a member's reappointment, the search cum selection committee must consult the head of the concerned tribunal, except for Central Industrial Tribunal under section 44 of that code, because there is an exception. The search cum selection committee recommends 1 suitable person per post, and 1 additional name for the waiting list. Waiting list only can be used in case the first person declines. In case the first person declines, then only the waiting list can be used. Presently, where the Supreme Court is not happy is that presently there is a process of recommending 2 names to central government, and the central government can opt any of the 2 names. But how is case is recommending only 1 name, and the second name can be used only in case the first declines. The Secretariat must forward the recommendation to central government within 3 days, and the central government must make an appointment within 3 months. So after the recommendation of search cum selection committee, the central government will have 3 months after even receiving the recommendations. So these are the basic procedural rules, and exactly the regulations will come and the rules will come. So there are, the section 15 also talks about the empanelment of experts. The Secretariat empanels domain experts on terms including conflict of interest safeguard specified by the regulations to assist in assessing candidates' suitability. Those experts then sit without vote on the concerned committee, search cum selection committee. So we actually have seen those experts also will sit on the committee in case any such expertise is required to be verified. So that is also very important, that there will be a panel of experts also with this NTC. Now, this is very important. Section 16 also empowers NTC for removal of chairperson and members of the tribunal. But there are circumstances under which the NTC can remove them. So the removal actually can be done by central government on the recommendations of the NTC, and that will be primarily on 4 grounds. One is the insolvency of the member or chairman. Second is conviction for moral turpitude. Third is incapacity. Fourth is prejudicial, financial or other interest. Prejudicial, financial or other interest. Then abuse of position, being found incompetent or inefficient, and engaging in any paid assignment during the term. So that means no one can be engaged for a paid assignment during this one. So for the grounds, last 4 grounds that I said, prejudicial, financial or other interest, abuse of position, being found incompetent and inefficient, engaging in any paid assignment during the term. For these 4 grounds, the administering ministry conducts only a preliminary inquiry into whether the complaint discloses a ground support by material, and then must refer the matter to the chairperson of the commission for inquiry. Removal cannot occur without such reference and inquiry, and the government act on the commission's recommendation. So the government will act on the commission's recommendation. Administering ministry will conduct preliminary inquiry, and then it will actually with the grounds of which are supporting the material, supporting the allegation, that will be referred to the chairperson of the commission for inquiry. The chairperson of the commission will make inquiry and then will find the actual facts and will also then recommend it to central government for any such action, which can be removal of the members of the tribunal or chairman of the tribunals. As I said, the Supreme Court has actually been saying that the term of the office of the chairman or the member of any tribunal, it should be 5 years. So this is what it is there in this bill, that the term should be 5 years or until the age of 70, a member of 5 years or until age 67, whichever is early, with eligibility for reappointment under section 14. Now the qualification, etc., like that also has to be this section in fact provides that provisions on qualifications, selection, appointments, salaries, resignation, removal, service conditions and reappointment in 14 parent enactment listed in first schedule stands amended as set out in the second schedule. So all the powers now are vested with NTC. All the powers are vested with NTC. There is a clear-cut demarcation like what would be covered in regulations and what would be covered in rules. The regulations will be made by commission and the rules will be made by central government. Let us understand what are the powers of the commission to make regulations and on what subject. So the commission may, in consultation with central government, even the regulations will also be made in consultation with central government. And central government, when I say, that means administering ministry. For each tribunal, there is an administering ministry, and the regulations will also be made in consultation with the administering ministry. Make regulations on, the commission can make regulations on conduct of its meetings. 2. Advertisement of vacancies and processing of applications. 3. Scrutiny and weightage for candidate assessment. 4. Empanelment of experts including conflict of interest terms. All regulations are supposed to be laid before Parliament with modification, annulment powers. So ultimately, with the permission of the central government, the commission can make regulations only on these issues. Now let us understand what the central government can make, because the rules are to be made by central government. The central government may make rules on Number 1, commission members' salaries and conditions. 2, the removal inquiry committee under section 6 subsection 3. 3, the secretary's administrative and financial powers. 4, the secretariat staffing. 5, annual accounts format. 6, qualification, selection, salaries and service conditions of tribunal chairmen or members under section 14 subsection 1 of the bill, of the comprehensive assessment procedure. And the last is the manner of removal, inquiries and all residual matters. So the most important issues are being handled by rules, by making rules by the central government, and the procedural issues are being handled by the commission, and that too with the approval of central government. That is what is very clear. And like we definitely have already said that what all is there. One issue here is that why NCLT is not covered in the schedule. Probably NCLT was the one such tribunal which was mentioned in section 184 of the Finance Act 2017, and it is only because of that maybe some amendment is required in either in the Finance Act or in the Companies Act, so then it will be notified. So the bill, the provisions of this bill also empowers the central government to add any tribunal through notification. There is a consequential amendment to all relevant acts. In fact, the last part of the bill is the consequential amendments in 14 acts. Like whatever act originally had this provisions of the tribunals, then the amendments are that as far as the selection, salary, every provision actually would be now dealt with the National Tribunal Commission. That is the last part of the bill. But what we finally can understand about this bill and about this constitution of National Tribunal Commission, that see, it's a very old struggle between the judiciary and central government, that these tribunals are being administered by the ministries, and at most of the time the tribunals are also hearing applications, petitions against the same ministry. This is one challenge which actually is being faced by, where the Supreme Court is also kind of pointing this out. Secondly, in the selection process there should be a complete independence, and the judicial independence like environment should be created. That's the second ask of the judiciary. With this National Tribunal Commission, it is hopeful that this struggle would be at end, and this will be completely a kind of coordinated effort, so that the tribunals are not faced with very high pendency of recruitments and no administration and no one particular setup, one particular institution who actually is looking forward to this kind of very important process of administering, recruiting, capacity building, training, and even creating a cadre of the employees at all tribunals. Hopefully, this bill will end this kind of struggle which is pending and which was in fact impacting the economy adversely. Thank you very much.